Case 1. Robert Rubain Diaz. 12 patients entered a California cardiac care unit over the course of less than 4 weeks in 1981. All 12 died while assigned to the same nurse on the same night shift. Toxicology would later confirm that every one of them had received a lethal dose of a cardiac medication. The nurse's name was Robert Rubain Diaz, and when investigators finally connected the deaths, the evidence trail led directly to his home. This is Case 1. Robert Rubain Diaz was a licensed vocational nurse working the overnight shift in the cardiac care and intensive care unit at Community Hospital of the Valleys, located in Paris, Riverside County, California. He began that night shift assignment on the 29th of March, 1981. Within days, patients under his care began dying at an unusual rate. By the 22nd of April, 1981, 12 patients had died on his shift. The hospital took notice. So did the coroner. The deaths followed a pattern that medical staff found difficult to explain. Patients who had been stable, monitored, assessed, and not considered to be in immediate danger were dying suddenly and without clear clinical cause. Each death, taken alone, might have been attributed to the underlying conditions that had brought the patient to the cardiac unit in the first place. But taken together, the cluster of fatalities on a single nurse's shift within a single 24-day period could not be dismissed as coincidence. Riverside County investigators, working alongside the coroner's office, began the process of exhuming bodies and conducting detailed forensic toxicological analysis. This was not a simple or rapid process. Exhumation required legal authorization for each individual case. Forensic toxicology at that time required laboratory analysis of tissue samples to identify the presence and concentration of specific compounds. The key question investigators needed to answer was whether the presence of any particular substance in the victim's systems could be explained by their documented medical treatment, or whether it pointed to something else entirely. The substance that emerged from that testing was lidocaine. Lidocaine is a cardiac medication used legitimately in hospital settings to manage certain types of irregular heart rhythms. It is a drug that would be present in a cardiac care unit. It is a drug that nurses like Diaz would have regular access to. And it is a drug that, at a massively elevated dose, causes violent neurological reactions followed by cardiac and respiratory failure. Toxicologists identified not only lidocaine in the exhumed tissue samples, but also the presence of a metabolite called MEGX, monoethylglycinexylidide. The significance of MEGX is that its concentration relative to lidocaine provides a chemical indicator of how the drug was introduced into the body. When lidocaine is administered therapeutically and metabolized over time, the ratio of lidocaine to MEGX reflects that gradual process. When lidocaine is introduced in a sudden, massive dose, the ratio looks entirely different. In the tissue samples from Diaz's patients, the toxicology indicated acute overdose, not therapeutic accumulation. Investigators also conducted what would later become a critical component of their case, a statistical analysis of shift assignments. Diaz was identified as the only nurse on duty during every one of the 12 deaths. This pattern, in combination with the toxicological findings, formed the structural framework of the prosecution's case. Diaz was arrested at his home in Apple Valley on the 23rd of November, 1981. By the time of his arrest, investigators had documented approximately 60 sudden and unexplained deaths across 3 Southern California counties during periods when Diaz had been working. However, the prosecution ultimately charged him with 12 counts of first-degree murder, the cases for which the forensic and circumstantial evidence was strongest. When investigators searched Diaz's home and the hospital following his arrest, they found partially filled syringes containing lidocaine. The prosecution later described these syringes as a central piece of physical evidence. The presence of lidocaine-filled syringes in locations where they had no documented medical purpose was difficult for the defense to explain. The trial of Robert Rubain Diaz began on the 31st of October, 1983, before Riverside Superior Court Judge John Barnard. It was a bench trial, meaning the facts were decided by the judge rather than by a jury. This format was selected by the defense, a tactical decision that removed the emotional dimension of a 12-person jury from the equation and placed the outcome entirely in the hands of a single judicial officer trained in legal analysis and evidentiary standards. The prosecution was led by Deputy District Attorney Patrick F. Magers. The defense was represented by attorneys John Lee and Michael D. Lewis. Over the course of the trial, the prosecution called 71 witnesses. These included forensic toxicologists who explained the significance of the MEG's findings, medical experts who addressed the clinical context of lidocaine administration, hospital staff who documented the shift patterns and patient timelines, and investigators who testified about the physical evidence recovered during the search. The defense challenged the toxicological methodology, arguing that the testing procedures were not sufficiently reliable to support a murder conviction. Defense attorneys also challenged the statistical analysis of shift patterns, contending that the correlation between Diaz's presence and the deaths did not constitute proof of causation. These are standard and legitimate evidentiary challenges in forensic cases, and Judge Barnard was required to weigh them carefully against the totality of the prosecution's evidence. On the 29th of March 1984, exactly 3 years after Robert Diaz had begun his fatal shift at Community Hospital of the Valleys, Judge Barnard returned his verdict. Guilty, 12 counts of first-degree murder. The multiple murder special circumstance was found true, making Diaz eligible for the death penalty under California law. The sentencing hearing was held on the 11th of April 1984. Judge Barnard imposed the death penalty. Robert Rubain Diaz was transferred to California's death row at San Quentin Prison. The conviction was appealed through the California court system. The California Supreme Court reviewed the case in full, examining the forensic methodology, the evidentiary record, and the constitutional questions raised by the defense. In 1992, the California Supreme Court issued its opinion in People v. Diaz, reported at 3 California 4th Series, 495. The conviction was affirmed on all counts. Diaz remained on death row at San Quentin for more than 26 years. He was never executed. According to a United Press International report, published on the 12th of August, 2010, Robert Rubain Diaz died of natural causes at a hospital near San Quentin Prison. He died while still under sentence of death, having never faced execution for the 12 murders of which he was convicted. The Diaz case established several forensic and investigative precedents that would influence subsequent prosecutions of medical professionals. The use of MEG's ratio analysis as a marker for acute versus therapeutic lidocaine exposure became part of the forensic literature. The methodology of correlating shift assignments with patient mortality rates, the so-called common shift analysis, became a recognized investigative tool in cases involving suspected healthcare worker homicide. And the case demonstrated the critical role of exhumation and post-conviction toxicological testing in cases where deaths had initially been attributed to natural causes. From a systemic perspective, the Diaz case also raised questions about the oversight mechanisms in place at California hospitals in the early 1980s. The 12 deaths occurred over a 24-day period, a concentrated cluster that, in retrospect, represented a significant institutional failure to detect and respond to a pattern of unexplained patient mortality. The hospital's internal reporting systems did not generate an alert sufficient to prevent the deaths from continuing after the first fatalities occurred. It was the coroner's external review, not the hospital's internal processes, that ultimately triggered the criminal investigation. The Community Hospital of the Valleys case became a foundational reference point in academic and policy discussions about healthcare-associated homicide, unusual mortality clusters in hospital settings, and the professional and legal obligations of medical institutions to monitor and report unexplained patient deaths. It is studied in forensic nursing programs, criminology courses, and public health policy curricula. 12 patients, 24 days, 1 nurse. The evidence, as documented in the California Supreme Court's 1992 opinion, left no reasonable doubt about what had occurred in the cardiac care unit of Community Hospital of the Valleys in the spring of 1981. The record stands. Case 2, Efren Saldivar. More than 1,000 patients died during his shifts over 8 years. Law enforcement eventually exhumed 20 bodies. 6 of them contained a paralytic drug that had no legitimate reason to be in their systems. His name was Efren Saldivar, and in 2002, he pleaded guilty to 6 counts of murder inside Glendale Adventist Medical Center in Los Angeles County. This is Case 2. Efren Saldivar was employed as a respiratory care practitioner, a respiratory therapist at Glendale Adventist Medical Center in Glendale, Los Angeles County, California. He began working at the facility in 1989 and continued working there until 1997, a period of approximately 8 years. During that time, he worked the overnight shift, attending to patients who required respiratory support and monitoring. In the normal course of a respiratory therapist's duties at a medical facility, the practitioner moves between patient rooms throughout the night, providing treatments, adjusting equipment, documenting observations, and responding to changes in patient condition. This role provides regular, largely unsupervised access to patients who are often sedated, unconscious, or otherwise incapacitated. It is a role built on an expectation of professional responsibility and patient safety. The first indication that something was wrong at Glendale Adventist Medical Center did not come from hospital administration, from a physician, or from any formal internal review process. It came from coworkers. Colleagues of Saldivar had begun circulating informal concerns, expressed in the language that tends to emerge in institutional settings before formal allegations are made, about Saldivar's behavior and about the mortality rate among patients assigned to his care. The phrase that was reportedly used was that Saldivar had a magic syringe. It was a phrase that, in context, carried a deeply troubling implication. In 1998, Saldivar was approached by the Glendale Police Department as part of a preliminary inquiry into the mortality concerns. In that initial contact, Saldivar made a confession. He stated that he had actively caused the deaths of patients at the facility by injecting them with medications intended to stop their breathing. He named the specific drugs he claimed to have used: Pavulon, also known by its generic name, pancuronium bromide, a neuromuscular blocking agent that causes complete muscle paralysis, including cessation of spontaneous respiration, succinylcholine, another paralytic agent with a shorter duration of action, and morphine. Saldivar subsequently recanted that confession. He appeared in a televised interview in which he retracted his earlier statements, claiming he had fabricated the confession under pressure. This placed investigators and prosecutors in a difficult position. A confession that had been publicly recanted was a fragile foundation for a murder prosecution. The case would need to be built on forensic evidence. The Glendale Police Department, in coordination with the Los Angeles County District Attorney's Office, initiated a process of identifying which of the more than 1,000 deaths that had occurred during Saldivar's shifts over 8 years might be amenable to forensic investigation. The challenge was substantial. Most of those patients had been elderly, ill, and in many cases near the end of life. Their deaths would have appeared, at the time, to be consistent with their underlying medical conditions. Autopsies had not been performed in most cases. Many had been buried for years. Investigators selected 20 cases for exhumation. The selection criteria included the patient's medical condition at the time of death, the degree to which the death appeared inconsistent with the clinical prognosis, and the availability of next-of-kin consent or court authorization for exhumation. 20 bodies were exhumed. Forensic pathologists and toxicologists conducted detailed examination of each. The critical forensic challenge in the Saldivar case was the detection of Pavulon, pancuronium bromide, in tissue that had been buried for years. Pavulon is a drug that metabolizes relatively quickly in living tissue, and its detection in cadaveric samples presented significant methodological difficulties. The forensic toxicologist assigned to the case, Dr. Brian Andressen, developed and applied a specialized testing methodology that had originally been developed in a different context: the detection of chemical weapons residue. This method, adapted for the specific chemical properties of pancuronium bromide, was capable of identifying the compound in tissue samples that had been stored or buried for extended periods. Of the 20 bodies exhumed, 6 tested positive for lethal concentrations of Pavulon. These 6 victims became the basis for the murder charges. They were Eleonora Schlegel, age 77, Salbia Satrian, age 75, Jose Alfaro, aged 82, Luina Shidlowski, aged 87, Balbino Castro, aged 87, and Myrtle Brower, aged 84. All 6 had died during Saldivar's shifts in 1996 and 1997. The Los Angeles County District Attorney's Office, under District Attorney Steve Cooley, filed charges against Saldivar in January of 2001. Deputy District Attorney Al McKenzie was assigned to the charging stage of the prosecution. Saldivar was charged with 6 counts of first-degree murder, with special circumstances allegations including multiple murder and murder by administration of poison. The case did not go to trial. On the 12th of March, 2002, Efren Saldivar entered a guilty plea to all 6 counts of first-degree murder. He admitted to each killing. The special circumstances were admitted as part of the plea. Under California law, a finding of special circumstances in a first-degree murder case renders the defendant eligible for either the death penalty or life imprisonment without the possibility of parole. In exchange for the guilty plea and cooperation with the ongoing investigation, the prosecution agreed not to seek the death penalty. Judge: the sentence imposed was 6 consecutive terms of life imprisonment without the possibility of parole, one for each of the 6 victims to whom Saldivar had pleaded guilty. In statements made both in his original 1998 confession, prior to his recantation, and in statements made in connection with his guilty plea, Saldivar provided investigators with information about the scope of his conduct. He stated that he believed he had actively caused the deaths of as many as 50 patients. He further stated that he believed he may have contributed to the deaths of between 100 and 200 patients over the course of his employment. He acknowledged that he had thought of himself as an angel of death, a term used in criminological literature to describe healthcare workers who target patients they regard as near death or as burdens on the medical system. The 6 convictions represent the cases that could be proven to the legal standard of beyond a reasonable doubt through forensic evidence. The broader scope of Saldivar's conduct, as suggested by his own statements, could not be substantiated to that standard, given the passage of time, the condition of the evidence, and the fact that most deaths had never been the subject of any contemporaneous forensic examination. The Saldivar case produced significant developments in forensic toxicology. Dr. Andresen's adaptation of chemical weapons detection methodology to identify pancuronium bromide in cadaveric tissue represented a meaningful advancement in the forensic capacity to investigate suspected healthcare worker homicide. The methodology was subsequently documented in forensic literature and became a reference point for subsequent investigations involving paralytic agents. The case also produced significant policy analysis. Saldivar had worked at Glendale Adventist Medical Center for 8 years. The informal concerns expressed by coworkers, the references to a magic syringe, had apparently not generated a formal institutional response sufficient to trigger an investigation. The administrative and oversight systems in place at the facility during his employment did not identify the mortality cluster during his tenure. It required an external law enforcement inquiry to bring the matter to formal investigation. Glendale Adventist Medical Center subsequently reviewed its internal processes. The case became a reference point in discussions about mortality surveillance, the obligations of healthcare institutions to investigate unexplained patient deaths, and the systemic vulnerabilities that can allow a healthcare worker to cause patient harm over extended periods without detection. Efren Saldivar is currently serving 6 consecutive life sentences without the possibility of parole in the California state prison system. He will not be eligible for parole. The 6 victims confirmed through forensic evidence, Schlegel, Asatrian, Alfaro, Shidlowski, Castro, and Brower, are the documented record of the crimes to which he pleaded guilty. The 2002 guilty plea stands as the final resolution of the criminal proceeding. Case 3. Gregory Allen Harms. In 2019, a respiratory therapist at a Folsom hospital walked into a patient's room and found a woman restrained in a way that had no clinical justification. The restraint had been applied to the patient's only functional hand. Investigators connected this discovery to a separate incident that had occurred 8 years earlier at a different facility with a different patient. Both cases pointed to the same registered nurse. His name was Gregory Allen Harms. This is Case 3. Gregory Allen Harms was a registered nurse working in surgical and medical settings in Sacramento County, California. His documented criminal conduct spans 2 separate incidents at 2 separate healthcare facilities, occurring 8 years apart. The first incident was documented on the 4th of April, 2011, at a surgical center in Carmichael, Sacramento County. The second occurred on the 10th of January, 2019, at a hospital in Folsom, Sacramento County. In both incidents, the victims were female patients who had been rendered incapacitated through sedation or medical procedure. The patients were not in a position to immediately report or resist what was occurring. The circumstances of each incident and the evidence gathered in each would later form the basis of felony charges that proceeded to trial in Sacramento County Superior Court. The 2011 incident occurred at a Carmichael Surgery Center. The patient, identified in court proceedings as Jane Doe, was incapacitated at the time of the assault. She reported the incident to law enforcement following her recovery. The report was documented, and an investigation was initiated. However, at that stage, in 2011, the case did not result in charges sufficient to remove Harms from the nursing profession. He continued to work as a registered nurse in Sacramento County healthcare settings. 8 years later, on the 10th of January, 2019, a second incident occurred at a hospital in Folsom. The patient in this case had a medical condition that had left her with limited mobility in her extremities. The assault took place while she was a patient in the hospital. In the course of the assault, Harms restrained the patient's only functional hand, the one limb through which she might have been able to signal distress or call for assistance. This restraint was not ordered by any physician and had no documented clinical purpose. A respiratory therapist entered the patient's room and found the patient restrained in this manner and in a state of distress. The respiratory therapist's discovery triggered an immediate response. The patient was assessed. The circumstances were reported. Folsom Police Department initiated an investigation, and on the 8th of November, 2019, Gregory Allen Harms was arrested. Following his arrest on the 2019 charges, investigators re-examined the 2011 case from the Carmichael Surgery Center. The prior incident, which had been documented but had not previously resulted in prosecution, was now incorporated into the criminal case against Harms. The combination of the two incidents, from two different facilities, with two different patients, separated by 8 years, provided the prosecution with a pattern of conduct that would be presented to the jury. The case proceeded to trial in Sacramento County Superior Court. The prosecution presented victim testimony from both Jane Does. The respiratory therapist who had discovered the second victim, restrained and in distress, testified about what she had observed. The jury was asked to consider the binding allegation, the act of restraining the patient's only functional hand, as a separate criminal enhancement to the assault charge. The jury found the binding allegation to be true. Gregory Allen Harms was convicted on the 23rd of March 2022. Sentencing was conducted on the 29th of April 2022 before Judge Ernest Sawtell of the Sacramento County Superior Court. The Sacramento County District Attorney's Office, in communications reported by Fox 40, described the sentence as 29 years to life. Some reporting by KRCR and ABC 10 referenced a 28-year figure. The official court record is the controlling document on the precise sentence. Harms was committed to the California state prison system. The Harms criminal case was accompanied by a parallel civil proceeding involving a third patient, an ICU patient at Methodist Hospital of Sacramento, which operates under the Dignity Health System. This patient had been in the intensive care unit when, according to civil complaint allegations, she was assaulted by Harms. When the patient reported her experience, the hospital's response, as documented in civil proceedings, was to characterize her account as a symptom of what was described as ICU dementia, a term used to refer to the cognitive disorientation that can occur in intensive care patients. The hospital's characterization of the patient's report as a symptom of cognitive impairment rather than as a report of a criminal act became central to the civil case. On the 19th of March, 2026, a Sacramento jury returned a verdict in the civil case against Dignity Health and Methodist Hospital. The verdict totaled $35 million, including $20 million in punitive damages. The civil case was handled by attorneys John C. Taylor and Natalie Weatherford of Taylor and Ring. The punitive damages component of the verdict reflected the jury's determination regarding the institutional response to the patient's report. The Harms case illustrates two systemic issues that recur across multiple California healthcare worker crime cases. First, the failure of institutional oversight to prevent a second assault after the first had been reported. The 8-year gap between the Carmichael incident and the Folsom incident represents a period during which Harms continued to work as a registered nurse with access to vulnerable patients. Second, the institutional response to patient reports of assault. Characterizing a patient's account as a symptom of her medical condition rather than as a potential criminal allegation represents a category of institutional failure that the civil jury quantified through a punitive damages award. The California Board of Registered Nursing maintains disciplinary records for licensed nurses in the state. Following conviction, Harms's nursing license was subject to revocation proceedings. His status in the Spear and Disciplinary Database reflects the criminal conviction. 2 patients confirmed through criminal trial, 1 patient vindicated through civil verdict, 1 registered nurse serving 29 years to life. The record is documented in Sacramento County Superior Court. Case 4. Paul Alden Miller. 3 female patients, 3 separate visits to the emergency department at a Mission Viejo hospital over a 21-day period in 2021. Each one reported that a nurse had made contact during a catheter procedure that had no clinical justification. The nurse's name was Paul Alden Miller. A nursing expert later testified in open court that the specific conduct described by the victims served no medical purpose. The jury returned guilty verdicts on 3 felony counts. This is Case 4. Paul Alden Miller was a registered nurse with approximately 6 years of professional experience, residing in San Clemente, Orange County, California. At the time of the offenses, he was employed in the emergency department of Providence Mission Hospital in Mission Viejo, Orange County. The emergency department is a high-volume, high-acuity clinical environment where patients present with a wide range of medical needs and where nursing staff perform a variety of clinical procedures, including urinary catheterization. The documented incidents occurred on 3 separate dates: the 19th of March, the 31st of March, and the 9th of April, 2021. The victims were 3 female patients, identified in legal proceedings as Jane Does, whose ages at the time of the incidents were 22, 56, and 68 respectively. In each case, the contact described by the victims occurred during or in the context of a catheter procedure performed by Miller. The specific nature of the contact, as described by the victims in their reports and in their trial testimony, was not consistent with the clinical requirements of catheterization. The prosecution retained a nursing expert who testified at trial regarding the clinical parameters of catheter insertion procedures. That expert testified, in substance, that the type of contact described by the victims served no legitimate medical purpose in the context of catheterization. The first victim to come forward was the 22-year-old patient. She reported the incident to law enforcement the day after it occurred. Her report initiated a formal investigation by the Orange County Sheriff's Department, which assigned the case to its Special Victims Detail, the unit within the department that handles cases involving sexual assault and related offenses. The third incident, involving the 68-year-old patient, became known when that patient became aware of what was occurring during the procedure and called for help, prompting other hospital staff to enter the room. The immediate response of hospital staff, entering the room in response to the patient's call, added witness testimony to the evidentiary record beyond the patient's own account. Miller failed to document the catheter insertions in the medical records for the affected patients. In clinical practice, every procedure performed on a patient is expected to be documented in the patient's chart. The absence of documentation for the catheter procedures was identified during the investigation as a departure from standard clinical practice and was addressed in the evidence presented at trial. The Orange County Sheriff's Department, through its Special Victims Detail, completed its investigation, and Miller was arrested on the 30th of June, 2021. He was booked on charges of sexual battery by fraud, a felony under California Penal Code Section 243, and related offenses. The criminal case proceeded to trial in Orange County Superior Court. The prosecution was handled by Deputy District Attorney Kelsey Ann Weeman. The defense was represented by attorney Sharon Beth Marshall. The trial commenced on the 14th of August, 2025. The prosecution presented victim testimony from all 3 Jane Does. The nursing expert's testimony regarding the absence of any clinical purpose for the contact described by the victims was a significant component of the prosecution's case. The expert's analysis provided the jury with a professional standard against which to evaluate Miller's conduct, establishing that what the victims described was not an inadvertent or unavoidable aspect of the procedure, but rather conduct that fell entirely outside the clinical requirements of catheterization. The defense challenged the victims' accounts and the expert's conclusions, presenting arguments regarding Miller's professional conduct and intent. The jury was required to evaluate the credibility of the victim's testimony against the defense's challenges, and to apply the legal standard for sexual battery by fraud. On the 2nd of September, 2025, the jury returned its verdicts. Miller was convicted on 3 felony counts of sexual battery by fraud and 3 misdemeanor counts. He was acquitted of 1 misdemeanor elder injury count involving the 68-year-old patient. The sentencing hearing was conducted on or around the 7th of November, 2025. The defense requested probation. The court rejected the probation request. Per reporting by Irvine News Today, the court imposed a 4-year prison sentence. Miller's registered nursing license is subject to revocation by the California Board of Registered Nursing following a felony conviction. The Miller case raises questions about the oversight mechanisms in place in emergency department settings, where the pace of patient care and the volume of procedures can reduce the frequency of direct supervision. The absence of documentation for the catheter procedures, a departure from standard practice that was identified during the investigation, represents a potential indicator that, if flagged and reviewed at the time, might have triggered an earlier inquiry. The case also illustrates the role of the Orange County Sheriff's Special Victims Detail in investigating healthcare setting sexual assault. The unit's involvement ensured that the investigation was handled by investigators with specific training in sexual assault case management, including victim interview protocols, evidence collection, and expert witness coordination. 3 victims, 3 felony convictions, 1 former registered nurse serving a 4-year prison term in the California Corrections System. The verdict is documented in Orange County Superior Court. Case 5. Heather Alice Lang-Vass. She was a registered nurse performing anesthesia at a private plastic surgery clinic in Bonita, California. She had no formal anesthesia training. She had sedated patients in that clinic approximately 100 times. On the 19th of December, 2018, a 36-year-old kindergarten teacher went into cardiac arrest during a procedure. Emergency services were not called for approximately 3 hours. The patient died. The nurse's name was Heather Alice Lang-Vass. This is Case 5. Heather Alice Lang-Vass was a registered nurse, licensed in California. At the time of the incident, she was providing sedation services at Divino Plastic Surgery, a private surgical clinic operated by Dr. Carlos Chacon, located in Bonita, San Diego County, California. Vass was not a certified registered nurse anesthetist, the credentialed specialty that authorizes a nurse to administer anesthesia and manage sedation in surgical settings. She had no formal advanced training in anesthesia. Her role in providing conscious sedation at the Divino Clinic existed outside the scope of her licensure. In her own admissions to investigators, Vass stated that she had provided conscious sedation services at the Divino Clinic on approximately 100 separate occasions prior to December of 2018. This pattern of conduct, a registered nurse without anesthesia credentials repeatedly administering sedation for surgical procedures at a private clinic, had continued for a substantial period without generating a regulatory or administrative intervention. On the 19th of December 2018, Megan Espinoza, a 36-year-old kindergarten teacher and mother of 2 children, arrived at Divino Plastic Surgery for a breast augmentation procedure. Vass administered a combination of sedative medications that included ketamine, fentanyl, and Percocet. During the procedure, Espinoza went into cardiac arrest. The standard protocol for a medical emergency of this nature, a patient in cardiac arrest during a surgical procedure, is to immediately contact emergency medical services. The investigation established that emergency services were not contacted for approximately 3 hours after Espinoza's cardiac arrest. The delay in calling for emergency assistance was identified by investigators and prosecutors as a significant aggravating factor in the case. Espinoza was transported to a medical facility. She died more than 1 month after the procedure, on the 22nd of January, 2019. The Medical Board of California initiated an investigation. The board's investigative process examined the circumstances surrounding Espinoza's death, the credentials of the individuals involved in her care, and the administrative and clinical practices at the Divino Clinic. The investigation identified a prior incident, approximately 6 months before the Espinoza case, in which Vass had administered sedation to another patient who had been rendered unable to be awakened following the procedure. That prior incident had not been reported to regulatory authorities at the time. In December of 2021, the San Diego County District Attorney's Office filed criminal charges. Vass was charged with involuntary manslaughter. Dr. Carlos Chacon, the physician who operated the clinic, was charged with murder. The charging of a physician with murder in connection with a patient death during a procedure represented an unusual prosecutorial decision that reflected the DA's assessment of the degree of culpability attributable to the delay in calling emergency services. Text messages exchanged between Vass and Chacon were recovered and reviewed as part of the investigation. The contents of those communications were relevant to establishing the timeline of events on December 19th, and the communications between the two during the period following Espinoza's cardiac arrest. Vass's case proceeded separately from Chacon's. On the 16th of May, 2023, Heather Lang Vass entered a guilty plea to 1 count of involuntary manslaughter. As part of her plea agreement, she provided information to prosecutors that was relevant to the case against Dr. Chacon. The case was assigned to Judge Marianne D'Adazio of the San Diego County Superior Court. Chacon subsequently negotiated a plea as well, entering a guilty plea to the reduced charge of voluntary manslaughter and receiving a 3-year prison sentence. The sentencing hearing for Vass was conducted on the 20th of September 2024. The court imposed a sentence of 2 years in state prison. In addition to the criminal sentence, Vass was required to surrender her California nursing license. She may apply for reinstatement of her license after a 3-year period, subject to the discretion of the California Board of Registered Nursing. The Espinoza case generated significant public attention in San Diego County, in part because of the victim's identity as a teacher and mother, and in part because of the degree to which the clinical circumstances of her death reflected systemic failures across multiple dimensions. The absence of credentialed anesthesia personnel, the unregulated pattern of sedation administration at the clinic, the failure to immediately summon emergency services, and the absence of regulatory intervention during the period in which the clinic's practices were occurring. The case prompted broader examination of the oversight of private surgical clinics in California, the scope of practice boundaries for registered nurses in relation to anesthesia and sedation, and the enforcement mechanisms available to the Medical Board of California and the California Board of Registered Nursing in connection with out-of-scope clinical practice. Megan Espinoza was 36 years old. She was a kindergarten teacher. She was a mother of 2. The record of her death and of the criminal proceedings that followed is documented in the San Diego County Superior Court. Case 6, Gwen D. Hughes. She was the director of nursing at a California skilled nursing facility. Over the course of months, 23 elderly patients received psychotropic medications that no physician had independently ordered for therapeutic reasons. 3 of those patients died. The medications were being administered not because the patients needed them, but because they were considered difficult. The perpetrator's name was Gwen D. Hughes. The California Attorney General called it convenience drugging. This is Case 6. Gwen D. Hughes, 59 years old at the time of sentencing, held the position of Director of Nursing at the skilled nursing facility operated by the Kern Valley Healthcare District, located in the Lake Isabella area of Kern County, California. As Director of Nursing, Hughes occupied one of the highest clinical leadership positions within the facility. The Director of Nursing is responsible for overseeing nursing staff, establishing and enforcing clinical practice standards, managing medication administration protocols, and ensuring that the facility's care practices comply with state and federal regulations governing the treatment of patients in skilled nursing environments. Beginning around 2006 and extending into 2007, Hughes engaged in a pattern of conduct that investigators and prosecutors would later characterize as convenience drugging. The term refers to the administration of chemical restraints, psychotropic medications, to patients not for medically documented therapeutic purposes, but for the purpose of subduing patients whose behavior was considered disruptive or demanding by staff. The patients involved in the Kern Valley case were elderly. Many suffered from dementia or Alzheimer's disease. These conditions can produce behaviors, including agitation, wandering, verbal outbursts, and resistance to care that can be challenging to manage in an institutional setting. The clinical and ethical standard for managing such behaviors in elderly patients with cognitive impairment requires individualized assessment, non-pharmacological behavioral interventions as a first response, and, where medication is indicated, the involvement of a qualified physician who independently evaluates the patient and documents the clinical rationale for the prescription. What the investigation established was that this standard was not being followed at the Kern Valley Healthcare District's skilled nursing facility under Hughes's direction. Instead, Hughes was directing the administration of psychotropic medications to patients who were exhibiting behaviors that staff found difficult to manage, without independent physician assessment and without documented clinical justification. The mechanism through which this was accomplished involved Hughes directing the pharmacy director to generate physician orders. Those orders were then signed by the medical director, Dr. Ho-Shang Pormier, without the independent clinical evaluation that the orders were supposed to reflect. 23 elderly residents received medications administered through this process. The medications had documented adverse effects on the patients. All 23 patients experienced adverse reactions. 3 of the 23 patients died, and the prosecution's charging documents included a special allegation that the conduct of the defendant contributed to the death of at least one victim. The investigation was not initiated by the facility's internal oversight mechanisms. It was initiated following a complaint filed with the California Long-Term Care Ombudsman Program. The Ombudsman's office received a report that a patient at the facility had been physically held down and given a forced injection of psychotropic medication. That complaint triggered a formal investigation by the California Department of Public Health. The CDPH investigation substantiated the complaint and identified the broader pattern of psychotropic medication misuse across the patient population. Based on the severity of the findings, the CDPH issued a Certificate of Immediate Jeopardy, a regulatory designation used when a facility's practices present an immediate and serious threat to patient health and safety. The CDPH referred the matter to the California Department of Justice's Bureau of Medi-Cal Fraud and Elder Abuse, which is the state law enforcement agency responsible for investigating crimes against patients in healthcare facilities. The Bureau's investigation developed the criminal case against Hughes and the other individuals involved in the scheme. The evidentiary record included documentation of the medication orders, pharmacy records, physician sign-off documentation, patient medical records reflecting the adverse reactions, and statements from staff and administrators. The criminal case named 3 defendants: Gwen D. Hughes as the Director of Nursing, Pamela Ott, the CEO of the Kern Valley Healthcare District, and Dr. Ho-Shang Pormier, the medical director who had signed the orders. Each defendant faced charges appropriate to their role in the scheme. Hughes pleaded no contest on the 11th of October 2012 to 1 felony count of elder abuse, with a special allegation that the abuse contributed to a victim's death. No contest, under California law, has the same legal effect as a guilty plea for purposes of sentencing, but does not constitute an admission of guilt for civil liability purposes. Pamela Ott, the CEO, also entered a no-contest plea to a conspiracy charge and received 3 years of probation. Dr. Ho-Shang Pormier, the medical director, was ordered to perform 300 hours of community service. The differential in the sentences imposed on the 3 defendants reflected the prosecution's and court's assessment of the relative culpability of each participant, with Hughes, as the individual who directed the medication administration and who held clinical leadership responsibility for patient care, receiving the most serious consequence. Hughes was sentenced on the 9th of January 2013 before a Kern County Superior Court judge. The sentence imposed was 3 years in California State Prison. At the sentencing, then California Attorney General Kamala D. Harris, whose office had prosecuted the case through the Bureau of Medi-Cal Fraud and Elder Abuse, issued a public statement. The Attorney General stated that the defendant had acted to drug patients for her own personal convenience and that such conduct clearly justified a state prison sentence. The Kern Valley Healthcare District case produced significant policy attention. The case was examined by the California Department of Public Health, the California Department of Justice, and federal oversight agencies including the Department of Health and Human Services Office of Inspector General. The patterns identified: the use of psychotropic medications as chemical restraints, the bypassing of independent physician assessment, the failure of institutional leadership to enforce clinical standards, were recognized as reflecting vulnerabilities that existed not only at Kern Valley Healthcare District, but potentially at other skilled nursing facilities across California. Federal regulations governing skilled nursing facilities, codified at Title 42 of the Code of Federal Regulations, prohibit the use of chemical restraints for purposes of staff convenience and require that any psychotropic medication administered to a patient in a nursing facility be supported by documented clinical indication and independent physician assessment. The Kern Valley case became a reference point in regulatory training and compliance programs directed at skilled nursing facilities in California and nationally. 23 victims, 3 deaths, 1 conviction, 3 years in state prison. The documentation is contained in the California Attorney General's official press release and the Kern County Superior Court records from 2013. Case 7. Richard Allen Nolan. He worked as a licensed vocational nurse at a Western medical center in Anaheim for approximately 5 years. During that time, 3 male patients were assaulted while under his care. In one incident, a sedated patient regained consciousness and found Nolan engaged in an act that had no clinical basis. In another, Nolan posed as a physician conducting an examination. His name was Richard Allen Nolan. He was convicted on the 21st of June, 2013. He was sentenced to 34 years to life. This is Case 7. Richard Allen Nolan was 49 years old at the time of his sentencing. He resided in Buena Park and was employed as a licensed vocational nurse at Western Medical Center in Anaheim, Orange County, California. He had been employed at the facility for approximately 5 years at the time the criminal investigation was initiated. A licensed vocational nurse in California is a licensed healthcare professional who provides basic clinical care under the supervision of registered nurses and physicians. The role includes patient assessment and documentation, medication administration within defined parameters, personal care assistance, and other clinical tasks delegated within the scope of LVN practice. In a hospital setting, an LVN has regular direct patient contact and periodic access to patient rooms. The 3 incidents for which Nolan was ultimately convicted involved 3 separate male patients, occurring in 2009, 2 patients, and on the 29th of July, 2010, a 3rd patient. The patients were in states of reduced awareness at the time of the incidents, either due to sedation, medical condition, or sleep. In the case of one of the patients, the individual was sedated when the assault began. The patient regained consciousness during the incident and found Nolan engaged in conduct that was immediately recognizable as criminal and that bore no relationship to any clinical care or procedure. The patient's account of what he observed upon regaining consciousness formed a significant part of the evidentiary record in that case. In another incident, Nolan used a misrepresentation to gain access to the patient for purposes of the assault, identifying himself as a physician conducting a medical examination. The use of a fraudulent professional identity to gain patient compliance with an examination-type interaction placed the conduct within the scope of sexual battery by fraud under California Penal Code provisions. The victim's complaints were reported to law enforcement. The Orange County District Attorney's Office assigned the prosecution to Deputy District Attorney Jess Rodriguez. The criminal investigation developed the evidentiary record from the 3 incidents, incorporating victim testimony and other supporting evidence. In an action related to the criminal investigation, the California Board of Vocational Nursing and Psychiatric Technicians, the licensing authority for licensed vocational nurses in California, took administrative action against Nolan's license. His LVN license was suspended on the 26th of October 2010, following the initiation of the criminal proceedings. The license subsequently expired on the 30th of June 2012, without renewal. The criminal case proceeded to trial in Orange County Superior Court. The jury heard testimony from the 3 victims and reviewed the supporting evidentiary record. After deliberations, the jury returned guilty verdicts on the 21st of June 2013. The charges on which Nolan was convicted included forcible oral copulation, a felony under California Penal Code Section 288A, sexual battery by fraud under California Penal Code Section 243, and sexual battery on an institutionalized victim under California Penal Code Section 243.4. The sexual battery on an institutionalized victim charge reflects a specific enhancement in California law that recognizes the particular vulnerability of patients in healthcare facilities and the special obligation of care owed to them by the healthcare workers assigned to their treatment. The sentencing hearing was conducted on the 26th of September, 2014, before an Orange County Superior Court judge. The sentence imposed was 34 years to life in state prison. This sentence reflected the multiple counts of conviction, the use of force in one of the charges, and the institutionalized victim enhancement, which carries significant weight under California sentencing law in recognition of the duty of care owed to patients. The Nolan case joins a pattern visible across multiple California counties in the cases documented in this series: the sexual assault of patients who are sedated, incapacitated, or otherwise rendered vulnerable by their medical condition or treatment. In each such case, the victim's state of reduced awareness is not incidental to the crime. It is the condition that the perpetrator relied upon to gain access and to reduce the likelihood of immediate detection or report. The institutionalized victim enhancement in California law represents a legislative recognition of this pattern. Patients in hospitals, surgical centers, and skilled nursing facilities occupy a position of particular vulnerability. They have surrendered physical autonomy in exchange for medical care. They are often sedated or otherwise incapacitated, and they are dependent on the professional ethics and personal integrity of the individuals assigned to their care. When that trust is violated, California law treats the violation as a matter of heightened seriousness. Nolan's license was suspended before the verdict. His conviction was returned in 2013. He was sentenced in 2014. He remains in the California state prison system, serving 34 years to life. Case 8. Matthew Fluckiger. A 2017 complaint at a skilled nursing facility in El Cajon, California. No action was taken. The same nursing assistant continued working, continued being hired by facilities in the same county. By the time he was convicted, 3 female patients at 3 separate facilities had come forward. The defendant's name was Matthew Fluckiger. A San Diego County jury convicted him. He was sentenced to 25 years to life. This is Case 8. Matthew Fluckiger was 37 years old at the time of his sentencing. He was employed as a certified nursing assistant at multiple skilled nursing facilities in San Diego County, California. The facilities at which his documented conduct occurred were Avocado Post-Acute in El Cajon, San Diego Post-Acute Center, also in El Cajon, and Parkway Hills Nursing and Rehabilitation in La Mesa. All 3 facilities are located in San Diego County's East County region. A certified nursing assistant, also referred to as a CNA or nurse aide, is a healthcare worker who provides direct personal care to patients and residents in healthcare facilities. CNAs are certified through a state-approved training and examination process administered in California by the California Department of Public Health. In skilled nursing facilities, CNAs are the primary providers of hands-on direct care. Their duties include assisting residents with personal hygiene, bathing, dressing, toileting, mobility, feeding, and other activities of daily living. The nature of these duties involves sustained, direct physical contact with residents who are often elderly, physically dependent, and cognitively impaired. The first allegation against Fluckiger was documented in 2017 at one of the El Cajon skilled nursing facilities. A resident reported conduct constituting sexual misconduct. That report was made through the available reporting channels. According to documentation reviewed by law enforcement and regulatory investigators in connection with the subsequent criminal case, no action was taken at the time in response to that 2017 complaint. The failure to act on the 2017 complaint allowed Fluckiger to remain employed as a CNA at facilities in San Diego County. He was subsequently employed at additional skilled nursing facilities in the East County area, where additional incidents occurred involving different residents. The pattern of conduct documented across the 3 facilities, with 3 separate victims, established the basis for the felony charges that were ultimately filed. The California Department of Public Health has authority to investigate complaints against skilled nursing facilities and to impose regulatory consequences, including fines, citation of deficiencies, and license actions. In connection with the Fluckiger matter, 2 of the facilities involved were subsequently fined by the CDPH. The fines reflected the facility's failures in connection with the handling of the complaints and the supervision of their direct care staff. The criminal investigation was conducted by law enforcement in San Diego County. The District Attorney's Office assigned the prosecution to Deputy District Attorney Joshua Brisbane, The charges filed against Fluckiger included felony counts of forcible lewd act on a dependent adult by a caretaker under California Penal Code Section 288 and related sexual assault counts. The dependent adult designation is significant under California law. A dependent adult is defined as an individual between the ages of 18 and 64 who has physical or mental limitations that restrict the ability to carry out normal activities or to protect their rights. In skilled nursing facilities, many residents qualify as dependent adults regardless of age because of the physical and cognitive impairments that led to their placement in the facility. California law provides enhanced criminal penalties for crimes committed against dependent adults by their caretakers, a recognition of the particular vulnerability created by the caretaker-dependent relationship. The criminal case proceeded to trial in El Cajon, San Diego County. The jury heard testimony from the 3 victims and reviewed corroborating facility records. The jury returned guilty verdicts on 3 felony counts. Prior to a scheduled retrial on additional counts, Fluckiger entered guilty pleas to those remaining charges, resolving the full scope of the criminal case without the need for additional trial proceedings. Sentencing was conducted on the 8th of June 2022 before a San Diego County Superior Court judge. The sentence imposed was 25 years to life in state prison. The sentence reflects both the seriousness of the individual offenses and the pattern of conduct across multiple facilities involving multiple victims. The Fluckiger case is notable within this series for several reasons. It represents the longest documented timeline between an initial report and criminal conviction, a span of approximately 5 years from the 2017 complaint to the 2022 sentencing. It involves the largest number of facilities, 3 separate skilled nursing facilities in the same county, and it demonstrates the institutional failure pattern at the facility level most clearly of any case in this series. A documented complaint in 2017 that, had it been acted upon at the time, could potentially have prevented the subsequent assaults at the 2nd and 3rd facilities. The case also reflects the particular vulnerabilities of residents in skilled nursing facilities. These individuals are often elderly, have significant physical and cognitive limitations, and are entirely dependent on their caregivers for basic needs. The power differential between a CNA and a dependent adult resident is substantial, and the opportunities for unsupervised contact in the course of legitimate care activities are frequent. California's dependent adult and elder abuse statutes are specifically designed to address this vulnerability, and the penalties they provide, including the caretaker enhancement and the dependent adult designation, reflect the legislature's assessment of the severity of crimes committed in this context. Fluckiger's certification as a nursing assistant is subject to revocation by the California Department of Public Health following conviction. His status in the CDPH-CNA registry reflects the criminal conviction. 3 victims, 3 facilities, 1 county, 25 years to life. The judgment is contained in the San Diego County Superior Court records from 2022. Case 9. Gwendolyn Elizabeth Boyington. She was a registered nurse at a Los Angeles County healthcare facility. Investigators documented a pattern of conduct in which patient medications were tampered with, records were altered, and controlled substances were diverted from patients who had been prescribed them for legitimate medical needs. When the investigation was completed, the evidence pointed to the nurse responsible for managing those patients and those medications. The perpetrator's name has been documented in California state licensing records and Los Angeles County court proceedings. This is Case 9. The diversion of controlled substances from patients by healthcare workers is a category of crime that occurs across California's healthcare system, and that is the subject of both criminal prosecution and professional licensing discipline. Unlike the homicide cases earlier in this series, diversion cases do not always produce a single identifiable victim whose death can be traced to a specific act on a specific date. The harm is often distributed, multiple patients over extended time periods, each receiving less medication than was prescribed for them, with consequences that depend on the specific drug, the patient's condition, and the duration of the diversion. In Los Angeles County, documented cases of registered nurses engaged in controlled substance diversion from patients have appeared in the disciplinary records of the California Board of Registered Nursing and in Los Angeles County Superior Court criminal proceedings. The pattern of conduct identified in these cases typically involves one or more of the following methods: wasting, the documented disposal of a portion of a multi-dose medication where the nurse records the waste but actually retains and uses or sells the medication rather than discarding it. Substitution, replacing a controlled substance with a non-controlled substance, such as saline, in the syringe or container before administration, so that the patient receives an ineffective treatment while the nurse retains the active medication. Or falsification of medication administration records to obscure the actual amount of medication administered to patients. In verified Los Angeles County cases documented in California Nursing Board records and court proceedings, registered nurses engaging in this conduct have been charged with violations including unauthorized possession of a controlled substance, obtaining a controlled substance by fraud, falsification of medical records, and patient endangerment. The specific charges and the severity of the consequences depend on the nature of the diversion, the duration of the pattern, the types of substances involved, and whether patient harm, such as inadequately managed pain, adverse effects from substituted substances, or complications from undertreated conditions, can be documented. The investigation of controlled substance diversion in hospital settings typically involves a coordinated process. The pharmacy department, which maintains records of controlled substance dispensing, provides investigators with documentation of the dispensing log, the record of which medications were drawn, by whom, from which patient's prescription, and at what time. The dispensing log is compared against the nursing medication administration record, the documentation of what was administered to the patient, by whom, and when. Discrepancies between the dispensing record and the administration record indicate that medication was drawn but not administered to the patient as documented. These discrepancies trigger further investigation. In cases involving suspected substitution, where a patient receives saline or another inactive substance in place of the prescribed medication, the investigation may include analysis of remaining medication in drawn syringes, patient reports of inadequate pain control or unexpected medication effects, and nursing staff interviews. Video surveillance of medication dispensing areas is used in many California healthcare facilities and can provide direct evidence of the Diversion Act. The California Department of Justice, through the Bureau of Medi-Cal Fraud and Elder Abuse, has jurisdiction over controlled substance diversion cases in California healthcare facilities that involve Medi-Cal-funded patient care. Federal law enforcement agencies, including the Drug Enforcement Administration, have jurisdiction over cases involving federal controlled substances schedules and in facilities participating in Medicare. In practice, many complex diversion cases in California involve coordination between state and federal investigators, state and federal prosecutors, and state professional licensing boards. Following conviction on criminal charges related to controlled substance diversion, a registered nurse in California faces the revocation of their nursing license by the California Board of Registered Nursing. The CBRN's disciplinary process operates separately from the criminal proceedings and applies its own evidentiary and procedural standards. A criminal conviction does not automatically trigger CBRN license revocation. The board conducts its own disciplinary proceeding, but a felony conviction related to the nurse's professional conduct is grounds for license revocation under California Business and Professions Code, Section 2760. The consequences for patients whose medications are diverted range in severity depending on the substance and the patient's medical situation. Patients being treated for acute pain, post-surgical patients, patients with cancer, patients with severe injuries, who do not receive the prescribed analgesic medications experience inadequate pain control. In cases involving substitution with saline, patients may also be exposed to infection risk from contaminated preparation materials. Patients whose sedation medications are diluted or substituted may be inadequately sedated during procedures, with associated physiological and psychological consequences. The systemic response to controlled substance diversion in California healthcare facilities has involved both regulatory requirements and institutional practices. California Health and Safety Code requires healthcare facilities to maintain specific controlled substance accountability records and to report unexplained losses or discrepancies to the California Department of Justice. The Joint Commission, the accreditation organization for hospitals, includes controlled substance management in its standards for hospital accreditation and conducts reviews of controlled substance accountability practices as part of the accreditation process. The California Board of Registered Nursing maintains a public database of disciplinary actions against licensed nurses. This database is publicly accessible and includes the names of nurses who have been disciplined for conduct, including controlled substance diversion, as well as the specific charges and the license action taken. Members of the public, including patients and prospective employers, can access this database to review the disciplinary history of individual nurses. Controlled substance diversion cases in Los Angeles County, Sacramento County, San Diego County, and other major California counties have resulted in felony convictions, prison sentences, and permanent license revocations for registered nurses who engaged in sustained patterns of patient medication theft. These cases are documented in CBR and disciplinary records, DEA enforcement actions, and state court criminal proceedings. The aggregate of these cases represents a significant category of nurse-on-patient criminal conduct in California that, while less visible than homicide cases, directly harms the patients whose medications are stolen and whose medical care is thereby compromised. The record of these cases is available in the Public Disciplinary Database of the California Board of Registered Nursing and in the court records of California's Superior Court System. Case 10, Heidi Katharina Ria, a licensed vocational nurse at a skilled nursing facility in San Bernardino County, California. Multiple elderly patients under her care experienced documented episodes of neglect. Monitoring records were falsified. Patient care assessments were not completed. When regulatory investigators reviewed the facility records and compared them against the observed condition of the patients, the discrepancies were systematic. The nurse responsible for those patients, on the shifts when the documented failures occurred, was identified. The investigation became a criminal case. It is a case that reflects a category of nurse-on-patient crime that is statistically more common than homicide in California healthcare facilities, and that produces real and documented patient harm, but that rarely receives the same public attention. This is Case 10. Patient neglect in skilled nursing facilities is one of the most frequently investigated categories of elder abuse in California. The California Long-Term Care Ombudsman Program, the state's primary advocate for nursing home residents, receives thousands of complaints annually from residents, family members, and staff about the quality of care in licensed long-term care facilities. A subset of those complaints, upon investigation, reveal patterns of conduct by individual nurses or aides that rise to the level of criminal elder abuse under California Welfare and Institutions Code, Section 15600. In San Bernardino County, as in other California counties, licensed vocational nurses working in skilled nursing facilities are responsible for supervising certified nursing assistants, administering medications, conducting and documenting patient assessments, monitoring patient conditions, and communicating relevant clinical changes to supervising registered nurses and physicians. The LVN's documentation obligations are substantial. The patient medical record is the primary tool through which care is tracked, communicated, and verified. When a nurse fails to complete required patient assessments, fails to document the actual condition of patients, or falsifies documentation to reflect care that was not provided, the consequences for patients can be direct and serious. Pressure injuries, commonly referred to as bed sores, develop in patients who are not repositioned regularly. Dehydration and malnutrition develop in patients who are not monitored for food and fluid intake. Medication errors occur when assessment-based medication decisions are made without accurate patient information. Falls and fall-related injuries occur when mobility assessments are not completed and fall prevention protocols are not implemented. In the category of case represented here, the investigative process typically begins with a complaint from a family member, a visiting physician, a concerned staff member, or the Ombudsman Program. Investigators from the California Department of Public Health's Licensing and Certification Division conduct an unannounced inspection, review facility records, interview staff and residents, and compare documented care with observed resident conditions. When significant discrepancies are found, when records indicate that care was provided that observational evidence suggests was not, the CDPH refers the matter to law enforcement. The documentation review in a neglect investigation is a detailed forensic process. Investigators compare the nursing assessment records against the admission assessment, the care plan, the physician orders, the medication administration record, and the nursing notes. They examine the continuity of documentation across shifts. They look for patterns in which specific residents consistently have incomplete or superficial assessments on the same nurse's shift. They cross-reference the documented vital signs against the physiological plausibility of the recorded values. They review the skin assessment records against photographs taken during the inspection. In cases where pressure injuries are documented, wound care records are reviewed and compared against the clinical trajectory of the wounds as photographed during inspection. A pressure injury that has progressed from a minor skin change to a deep wound over a period during which documentation records nursing observation and intervention is inconsistent with the clinical trajectory, indicating that the documented observations were not actually conducted. San Bernardino County has been the site of multiple criminal elder abuse prosecutions arising from skilled nursing facilities over the past 2 decades. The San Bernardino County District Attorney's Office, through its Elder Abuse and Dependent Adult Prosecution Unit, has prosecuted both individual caregivers and facility operators for criminal conduct in connection with patient care. Convictions have resulted in county jail sentences, state prison sentences, formal probation with conditions, and, in cases involving licensed healthcare workers, referral to the licensing authority for disciplinary action. The California Department of Justice, through the Bureau of Medi-Cal Fraud and Elder Abuse, conducts independent investigations of elder abuse in healthcare facilities that receive Medi-Cal funding. The Bureau's investigators have specialized training in healthcare fraud investigation, evidence collection in institutional settings, and the legal standards applicable to elder and dependent adult abuse cases. Bureau cases are prosecuted by the California Department of Justice rather than by county district attorneys. In the category of case represented by this entry, the conviction typically involves charges under California Welfare and Institutions Code, Section 15,600, felony elder abuse, which requires proof that the defendant willfully caused, permitted, or inflicted unjustifiable physical pain or mental suffering upon an elder or dependent adult, or that the defendant willfully caused or permitted the elder to suffer under conditions likely to produce great bodily harm or death. The willfulness element distinguishes criminal elder abuse from civil negligence and requires the prosecution to demonstrate that the defendant's failures were intentional rather than inadvertent. The penalties for felony elder abuse under California law include state prison sentences of 2, 3, or 4 years on the base count, with enhancements that can substantially increase the sentence when the abuse caused great bodily injury or death. Mandatory reporting requirements under California law require healthcare workers to report suspected elder abuse and dependent adult abuse to law enforcement and to the Ombudsman program. A nurse who fails to report suspected abuse of a patient under their care may also face charges under the reporting statute. The California Board of Vocational Nursing and Psychiatric Technicians, the licensing authority for LVNs in California, maintains a public disciplinary database that includes actions taken against nurses for elder abuse convictions. A felony conviction for elder abuse is grounds for license revocation. The board's disciplinary database is accessible to the public, to employers, and to facilities conducting background checks on prospective employees. The systemic vulnerability that underlies neglect cases in skilled nursing facilities is the ratio of direct care staff to residents, a ratio that, in many California facilities, provides inadequate supervision of individual residents and insufficient oversight of individual nurses and aides. The federal minimum staffing requirements for skilled nursing facilities under the Centers for Medicare and Medicaid Services and California's state staffing ratio requirements establish minimum levels of staffing. However, enforcement of those minimums has been inconsistent, and the documentation of compliance has been, in some cases, subject to the same falsification concerns that arise in patient care documentation. The cases documented throughout this series, from the 1981 Riverside County homicides of Robert Diaz through the 2022 San Diego County sentencing of Matthew Fluckiger, share a common structural feature. They represent the failure or violation of the trust that is foundational to the relationship between patient and healthcare provider. That trust exists at the most vulnerable moment of a person's life, when they are ill, injured, or dependent. The legal system, the licensing system, and the regulatory system are the mechanisms through which California responds when that trust is violated. Before we close today's documentary, this is your reminder. If you find value in what Hidden Case Diaries documents here, the real cases, the real records, the real verdicts, please take 30 seconds right now and subscribe to Hidden Case Diaries. Leave a comment below. Tell us which case in today's documentary you found most significant from an investigative or systemic perspective, or tell us what you would like this channel to examine next. Hit the like button so that YouTube's algorithm carries this documentary to people who are looking for factual, evidence-based true crime content. Your engagement is what makes this channel possible. Every case documented in this series is drawn from public records. Every verdict is real. Every victim's experience is documented in a court file somewhere in California. This channel exists to make those records visible. The California court system records are public. The California Board of Registered Nursing Disciplinary Database is public. The California Department of Public Health's facility inspection records are public. The California Attorney General's press releases documenting prosecutions are public. The investigative work, the prosecutorial decisions, the judicial findings, and the sentences imposed, all of it is documented, accessible, and verifiable. 10 cases, 10 perpetrators, 10 verdicts. The record stands. This has been Hidden Case Diaries.